Best of luck to you. Shankleton, Brian Shankleton. Brian William Shankleton, 230-240-59. Mr. Shankleton, your name?
Brian Shankleton.
Mr.
On behalf of the plaintiff, Your Honor.
No. I'm going on a criminal case now.
Oh,
Where
okay.
is Mr.
I sent him a text.
Mr. Shemke? I've said it before, officer. I'll say it again. When I was a lawyer, I waited for the judges. You know that? Now I wait for all lawyers. It's like, what has happened?
He was just outside.
I know, but he's got one case.
He had his phone in his hand.
How you doing, Judge?
I'm doing all right. My golf game stinks, but other than that, I'm doing all right.
Well, we have that in common. Look at us.
I'm telling you. Come on in, Mr. Shemke. Yeah, it's about as bad as I remember it in a long time. Maybe it's age.
Good morning, Your Honor. Mr. Shankleton, here again for my client. 717 being arraigned via Zoom.
Mr. Shankleton, your name?
Brian Shankleton.
All right, officer, your name?
Officer Weidrich, Flat Rock Police.
All right, what have I got here? I got a show cause for failure to pay. It looks like it's $477.
Yes, Your Honor, I did have a dialogue with my client. As to the arraignment, we're waiting for reading my client's statements mute. He's going to admit that he didn't pay, but I don't believe that this was malicious. I did read the notes and saw that the third party that posted the bond, they went and took that money back. My client was not aware of that, so he's apologetic, but it's his goal to get his financial constraints squared up within the next week.
Well, he's going to be sitting in jail then. Mr. Shankleton.
Yes, sir.
I told you to pay that day, didn't I?
We posted a bond. I posted a bond with you, and you took the money. You took the bond paid for all of my whole thing.
Who is Christina Bamia?
My ex-girlfriend.
Well, she posted the bond. That's what the records indicate. That means she has to come in and take care of the bond.
Yeah, she came in and got the money back for the bond and never told me anything about it. We were broken up. Yeah, I didn't even know. I thought it was all paid. I didn't even know.
Where do you work, Mr. Shankleton?
I have my own company.
I'm sorry?
I have my own company.
What kind of company?
Roofing and construction.
What? You're not working a lot?
Yeah. My wallet's at home.
Your wallet's at home.
Yeah.
Can you get somebody to bring your wallet to you that's at home?
No.
Who do you live
my
in?
house is. I live by myself.
Where was he picked up, officer?
In the county of Monroe. I did try to clarify. He was unsure if it was Monroe County or if it was Monroe City police or deputies. He was unsure. I would have to look at the report. I don't have it in front of me, Your Honor.
Was he charged to Monroe, do you know?
According to him, no. I wouldn't know that either, sir.
Where were you picked up at, Mr. Shankleton?
At my house.
They came to your house?
Yeah, I called them.
You called them and said, come arrest me?
Judge, he was having an assistant at that time. When the police did an interview with him, he was not charged with anything, but they discovered that they had this outstanding warrant to put him into custody. But he did not get charged with the new case. In fact, he was the one who called the police for assistance.
Mr. Shankleton. You walked out of the building. You were in person here, weren't you, on this date?
Yes, sir.
Now, Mr. Shankleton, forgive me. I don't want to sound like a doubting Thomas, but this case emanated back from the events that occurred in May of 23.
Yes, sir.
Now, I wish it was May of 23 because I'd be like 26 months younger. But the fact is, you played with us on this, and then we took care of it March 20. I sentenced you, and then you don't show up. So your ex-girlfriend who posted the bond came and got the money, and then you called the police because there was an altercation between you and your ex-girlfriend, and you never checked to say, hey, did you sign over the bond money so the court got their money? She never told you, you never inquired.
I was under the impression that it was all paid for.
Has he been cooperative with you guys?
Yeah.
Officer?
Yes, sir.
Now, Mr. Shankleton, I'm gonna say something to you. I'm gonna go let you get your money.
Okay.
Just be honest with me. Look me in the eye. You won't be the first that lied to me if you are. Do you have the money to come back and pay this?
I can pay for half of it.
Well, you didn't tell me that before, so you're being less than honest with me already. You said, oh yeah, I just don't have my wallet. The implication was that you were going to pay all of it. Why are you doing so bad in life? How old are you?
30.
Oh, come on. You don't have $325 or $477 to your name?
I do. It's just tied up. I got to pay my rent. My rent's $1,200 a month.
You're not working hard enough.
I cut my finger in half. I can't really work at all.
You didn't tell me that either until just now. Mr. Shankleton, do you have any kids?
No, sir.
Are you married?
No, sir.
Of course you're not. You had a girlfriend, unless, right. So let me ask you a question. I want you to be honest with me as to when you can pay this.
Within the next week.
Can you pay? Now, don't lie to me. You lie to me this time. You don't pay in the next week. I'm telling you, when you come back, I'm going to lock you up. This is in or 60 days. I could send you for 60 days right now. You want to be sitting in there until after Labor Day, mid-September?
No, sir.
I mean, Flat Rock's a very nice place, but I'm sure there's better places you'd like to stay.
Yes, sir.
Now, can you or can't you go get some money today?
Yes, sir.
All right, here's what we're going to do. Defendant to pay $75 per week. That's all I'm going to ask you to pay. Beginning today. Every Monday, you're to come in here. If you don't have the $75 next Monday or the Monday thereafter, no problem. Call the court, go on Zoom, or walk in here on or before the due date, 8:30. I'll give you an extension.
Okay.
Easy to deal with unless you act like a criminal. And right now, you're acting like a criminal. Now, I want you to know that I'm looking at your record right now, and nobody's going to accuse you of being a choir boy, okay? All right? It's time to transform your life, son. You want to go out like this, acting like this, drugging around, committing crimes, running from the police, God bless you, go for it. It's your life, not mine. You got a whole lot of years ahead of you. It's time to grow up. If you're 30, at least act like you're 20. So far, you're not proving to me that you're doing that. Okay, fair enough?
Yes, sir.
You don't have the money, what are you going to do?
I do have the money.
If you don't have the money on any of these pay dates, what are you going to do?
I'll call you.
Well, I'm not getting on the phone with you. You're calling the court and we're going on Zoom, or you're coming in here on or before the date. Do you understand that?
Yes, sir.
All right. Grow up. Life's a lot more fun when you're not running around from the police. And good luck. Against Zanatti. Thanks, officer.
Thank you, Your Honor.
Zanatti, 25W838192.
Good morning, Your Honor. Mr. Shankleton, with my client who approaches and stays in my immediate lot.
Your name?
Michelle Sinati?
Come on up to the podium. Where you been?
Pardon?
Where have you been? Where have you been? You were supposed to be here back in April. You wouldn't like it if I didn't show up till July if you were here in April. Where you been?
I was unaware that there was a court date issue, and it's my apologies. I never was my intention.
They gave you a
to
ticket.
not appear.
They gave you a ticket that day, right?
Judge, she hasn't had a lot of familiarity with this kind of charge. She thought that it had to be handled through the Secretary of State. When she did find out about this by not picking up a new charge, she immediately walked in, even with constraints that she has. She was in a very bad accident last week, but she came in, she understands.
All right, does she stand me away from a reading?
Yes, sir.
Do you live in Coldwater?
I do not.
Did you change your address with the Secretary of State?
I haven't secured a sole address yet. I'm kind of in between residences.
Well, where are we supposed to send your notices to, ma'am?
I can provide an address.
All right. What's your
I live
address?
in Woodhaven.
What's your address?
I just don't know it by heart yet. I'm going to look at it real quick. I can provide it before I leave.
Jennifer, tell Lisa to get her address, will you? I'm gonna do a pretrial date here, July the 23rd. That'll be at 10:30 in the morning. I will give you a personal bond of $500. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
I do.
If you want to petition, do you work, ma'am?
Not right now.
When did you last work?
Actually, just a few days after I was told about the suspension, I was unable to drive at that point, so that impacted my ability to work.
Where were you working?
I was working at Shish Garden full time.
All right, make sure you show up. Go down the hall, we'll give you a notice, fill out a petition for court appointed lawyer, we'll see you back here. Good luck.
I apologize.
All right, have a good day.
Thank you, Judge.
Marion Manor versus Frank Duncan, 2502622.
Carolyn
Yes,
Cohen,
Judge.
249391, appearing on behalf of the plaintiff, Your Honor.
Mr. Duncan, your name?
Frank Duncan.
Did you listen to and understand the rights?
Yes, I did, but
Hang on.
okay.
Do you wish to speak to a lawyer?
yes, I do. Sometimes, yes, I do.
Do you intend to apply for funding?
Yes, I do. But let me let you know, Judge, that I was served the summons last Tuesday night. I only had 3 days to get all this stuff together. I called Lakeshore twice. I've called Marion Manor 2 times, and I always left a message. I talked to the receptionist. They never call me back, and they just leave me.
Well, they sent you a letter. It looks like they sent you a letter. Marion Manor did on June 6th, the demand for possession demand for possession, non-payment of rent. They sent that to you. It says, according to them, that they mailed it on June 6th. So hang on. So you've known about it for about 5 weeks or so, right?
No, Your Honor. Let me explain something. I had car problems a few weeks before June, so that threw my schedule off. And I called them before the beginning of June and told them that I would pay them on the 25th of June, in which I did. And I'm looking at the summons here. It says the last payment that they received was on end of May, which is false.
Wait a minute. Slow down. Slow down. Wait. I'm not getting a good connection at all. I'm not getting a
Okay.
connection at all. You got to get closer to your device.
Okay, I'm trying.
A lot better.
Can you hear me better? Okay. Yes. So I called them at the beginning of June, letting them know that I was going to be late for the payment because I had auto problems. Okay. So I told them that I would be paying them on the 25th. And then they said, okay. And then they called me on the 6th or 7th saying that they're filing court. And I said, I told you I was going to pay you the 25th. And they said, oh, okay. Yeah, okay. We still got to do it. It's standard procedure. So the 25th came around. I paid my rent. And then they said, okay, we'll contact legal. And that's the last I heard of them. And then 2 days later, I got a thing scrolled up. It looked like a flyer. I didn't read it until a day later. They were demanding $120 from me. And I called them up. I said, what's the $120 for? Well, they said it was for filing for the claim.
Well, but listen, sir, in fairness to them, I'm certain they had multiple people tell them, I'll pay you later. They don't have to wait. That's not fair to them.
See, the thing is, they didn't file.
Let's slow down. Ms. Cohen, can you tell me what the balance is?
Yeah, it's 1451.54.
All right, so Mr. Duncan, I don't know what else you want me to do. I'll let you speak to a
I'm going to try
lawyer.
to explain it to you, Judge, as clearly and as possibly as I can. Okay, they got paid the 25th of 1,065. Okay, and that was June 25th, and they will get their money on. Did you say something?
No, I do want to make clear, I'm looking at this notice to quit. It says $85 late fees. I want all the managers to listen.
They said that the
Hang on,
manager.
hang on. I cap my late fees at $70. If I see anybody charging more than $75 or $70 rather, late fees, I promise you, because this is happening too much. I mean, I trust lawyers are going to tell me and adjust before they get on. I promise you, I will require, if I catch somebody charging late fees in excess of $70 a month on a case when filed, I promise you, as long as I'm sitting on this bench, each and every manager that I see that happening with will be required to show up in person there going forward, as long as I sit on this bench. And right now, as it sits, I've got 5.5 more years. So when you guys send out and you do these $85 things, I'm telling you, I will require you. I'll make your life miserable. You see my name on a pleading as the judge, you make sure it's capped at $70 per month. And just for the record, I've got the managers from Tanglewood here, Hidden Garden here, Marion Manor here, in Hamptons. Would you pop in your head, please? And I want you to acknowledge. Tanglewood, what's your name?
Sarah Baumier.
Your Honor, can I say one thing?
Not yet.
Okay.
Marion Manor, what is your name?
I'm the assistant manager, Caitlin Cahill.
You're going to tell the manager I've said what I said, correct?
Will do.
Ms. West, your name? John, can you warm that a little more? I need you. And from Hamptons, who do I have?
Jessica
Jessica what?
Brown.
And you're the assistant manager.
No, I am a leasing agent.
Okay. So we're going to make sure, Shelley West, you have to unmute bottom left-hand corner of your screen.
No, that's without it. Now it is.
Shelley West, give me a thumbs up if you can hear me, and you need to figure out how to show up on Zoom. She can hear me. She understands. You understand? Is that a yes? Yes, she's nodding her head up and down. I'm only telling you guys, I still see this happening. I'm trying to be nice and understanding about it. I'm not going to be anymore. And I don't care if any judge gives you $400 a month. I really don't. In late fees. I'm not. This is the extent of it. So that being said, Mr. Duncan, now you can go on and tell me why all of this that you're talking about is relevant. You paid for June. I get it. They started a court case. They had the right to do it.
Okay, Your Honor. Now, I'm confused. They sent me this flyer stating that I owe them $120. This is towards the end of June. Okay. Now I only owe for July, which is coming up with because when you collect Social Security, you get paid every month.
Slow down. Okay? How much is your monthly rental rate?
$1,065.
All right, so you owe 1,065. You probably owe for late fees for June and July. That's 70 a month. That's 140. That takes your total to 1,205. How much do you have in court costs, Ms. Cohen? You have to unmute.
176.54. I can give you the breakdown if you'd like.
Please.
Okay, so he went in from at the end of June after he paid $1,050. He had a $221.54 balance. Okay, and then he owed 1,000. So he owes $1,205 for rent, $170 late fee, and $176.54 for court costs, which equals $1,451.54.
Any reason to dispute that, Mr. Duncan?
Yes, I do dispute it because first of all, the manager, Caitlin, she's still there. She can hear me. She waived the late fee for when I called her up and told her that I was not
All
gonna
right,
make.
let's have the manager come in here. State your name, please.
I'm the assistant manager, Caitlin Cahill.
Do you know anything about what late fees being waived?
I'm looking. It doesn't look like any late fee was waived, no.
Is the manager working to, hang on, Mr. Duncan, is the manager?
The property manager is off today.
I talked to Caitlin directly to her when I called her because she put me in my place when I called her. Why are you running this through the court?
I just told you that we could not stop the filing.
I know what you
Mr.
said.
Mr. Duncan. Honestly, sir, I don't mean to be rude. I've heard enough of this. I want you to tell me how much you think you owe, because on my math, you at least owe 1,205 plus 176.57, which is 1,381.57. So I don't know what we're quibbling about, or 54 rather. Can you just waive the one late fee or not, Ms. Cohen?
I don't generally waive late fees, but I mean, if you're
I'm not asking you to then. If you don't want to do it, you don't want to do it.
I mean, we're talking about the month of July.
I know.
July 14th, and he hasn't paid.
I know. When are you going to pay this, Mr. Duncan?
Like I said, for the 10th time, I get paid every fourth Wednesday of a month.
The 10th time? Okay.
Well, I did say it quite a few times.
All right. Well, then forgive me. In the heat of the moment here and all the excitement, I must have not caught that. And you did say something about Social Security, but you're going to have to figure out how you're going to pay your rent on time. You're going to be paying $70 late fees every month, sir.
I understand that.
All right. So the fourth Wednesday is the 23rd, right?
Correct. A week from Wednesday, they will be getting their money.
All right. If they don't waive their, Ms. Cohen, here's what I'm going to do. I'm going to split that one in half. I'm going to give you $1,416.54. So I'm splitting that late fee in half. I probably should not be doing that, but I am. So it's going to be $1,416.54. Judgment after hearing. Writ date will be, I'll just make sure and give you until the 25th, which is a week from Friday. Okay, Mr. Duncan?
Okay, I'm not understanding what you're saying. You're splitting fees and all that. What's going on here?
Well, you owe $1,000. You owe $1,065. Okay. You have a $70 late fee for this month. That would bring your total to $1,135.
Right.
You have $176.54 that you owe in court costs. So no matter how you cut it, you owe $1,311.54. Wait a minute.
That's how much I owe by Wednesday.
And then I'm going to give him, I see what I did here. I added in that twice. The total amount, Ms. Coleman, is going to be $1,311.54 1346.54. I think that's a little different than what I said before. 1346.54. I might have made a mistake on that too. But you definitely owe 1,065 plus 70, which is 1,135, plus
Yes.
176.54, which is the court cost, for a total of 1311.54. And then I'm just giving them half the late fee for the last month. So
Well,
that's up to 35.
I have it at 1416.54 if you're only charging a $35 late fee.
All right, let's start over. My mistake. Give me the rent to retain right now is 1,065. Is that right?
Nope, the rent to retain is 1205.
Well, that includes two late fees of 140.
No, that's not, no, I broke it out separately.
All right, start over.
1205 in rent.
Okay.
Where is the other?
Okay,
You went out. I got it. 1205 in rent, and you have late fees, let's call them of 105, right?
no, I had a late fee of $70. Now it's gonna be $35.
You got a late fee for July of 70, right?
Yeah, but now it's gonna be 35.
No, I was only talking about the June late fee. That was in conjunction with the June 6, June 25. So I'm giving you 70 plus 35 for June. So that's 105. That should be 1310. And then you've got court costs of 176.54, right?
What's your total?
Well, 1310, and that is 1481.54.
Yeah, but the problem is now you're coming out with more than I had. Because I said the balance from if you take the balance of the previous month, I mean, it's hard because I'm looking at a ledger and I'm seeing his rent is 1,065 and I'm sorry, 1,000, when then he's got a insurance thing, so it's 1,085.
Okay.
Okay, and then I have a $70 late fee. And then
all
I
these
have court costs, but I'm not
fees,
giving, but we're not talking about the money from last, when you, going from last month, it's 221.54 minus.
So you're saying you still had a balance coming into July?
Correct.
So we had 1,065 plus 221. I mean, even a dummy like me can figure out that's 1886.
No.
I mean, 1286 plus late fees, right?
When I add 1286, when I add 1,085 and 221.54, what do you get?
Right. 1286.54. Then you still have to add on court costs, which are 176.54, you told me, right?
Yes?
What are you coming up with?
My total, according to my ledger, was 1451.54 with the
You don't-
$70 late fee.
You told me that before. And then that's when I said, why don't I cut off $35 of the late fees and make it 1416.54?
And I agree.
Right. So, Mr. Duncan, tell me why you don't owe 1416.54.
Well, first of all, I never heard of such exorbitant court costs. Your Honor.
Mr. Duncan, listen to me. I'm not going to let anybody take advantage of you. That's what the court costs are. I don't dictate what the court costs are. They're entitled to a $75 statutory attorney fee. They paid a M filing fee. They're entitled to those costs. I mean, you might disagree with it, write the legislature. I don't know what to tell you.
Well, Your Honor, first round they never filed for court
Mr. Duncan,
because all I
Mr.
got was.
Mr. Duncan,
Oh.
listen to me. You got to tell me what you think you owe, and you got to include court costs and late fees. Now, I've got all these people waiting here. I don't mind going on. If you want me to go on to another case, I'll be glad to give you time. But I cannot stand when people have figures and they say, well, I don't owe that much. Well, what do you owe? Well, I owe around. No, there's answers to math. This is not like arguing over what res ipsa loquitur means. This is just straight math.
Well, I know how to do math, Judge.
Well, then tell me how much you owe. Tell me how much you owe. How much do you owe and how do you calculate it?
I'm telling you, all these fees hit me 10 minutes ago. I didn't know all these fees existed.
Take your time, look at the fees, figure it out. I'm going on to another case, and then I'm going to ask you how much you owe when I come back and how you calculated them, period. I don't want to sit here and argue about it. I'm going on to Monica Brown, Marion Manor versus DeMonica Brown, 2502633. Miss Brown, your name, ma'am? You have to unmute and state your name, Ms. Brown. Start your video. Where's DeMonica Brown? Is she coming out or not? There she is. You have to start your video, ma'am. You appeared for about a second. There you go. Your name?
Okay. My name is DeMonica Brown. Sorry about that.
That's okay. Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Ms. Cohen, your appearance?
Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
All right. So tell me how much she owes. Total balance.
Total balance is $2,671.59.
All right. Now, Ms. Brown, do you agree that you owe that amount?
Yes.
When can you pay that?
I was hoping that I could speak with Ms. Cohen to work out a payment arrangement.
Tell me how much you can pay. I can help you.
Okay. Well, I'll have the $1,250. Sorry, I wrote it down. On the 23rd.
Okay.
And then I don't get paid again until August 6th. I was hoping that if we add in August, that I can have everything, all of the balance paid by the 21st, if she was willing to work with me, because I had just lost my job.
You want to talk to her in a breakout room after this? Ms. Cohen?
Yeah, that's fine. I can just tell you that if she can pay the balance of what she owes now by August 6th, that I can wait until August 21st to take the August rent.
If defendant pays $1,200, $1,250 you said, or
yes, $1,250.
If you pay $1,250 by July 24th, writ date extended until August the 6th, you said, right? Right, ma'am? Ma'am, you can pay the rest by August 6th?
Oh, yes, sir. I'm sorry. I didn't know if you were talking to me or
That's okay. If defendant pays $1,250, so I'm going to give you a judgment for $2,671.59. If defendant pays $1,250 by July 24th, writ date extended until August the 8th. But then you have to work out with Ms. Cohen paying the others, okay? Paying the August rent, all right?
Yes, sir.
Well, Your Honor, I thought she said August 6th.
She did.
Okay, you had said August 8th.
Okay, well, I wrote down August 6th. I made a mistake then. I'm sorry.
It's okay. Can we make that part of this hearing though, that she's gonna pay the August rent by the 21st?
You know, I hate to include months. I mean, if you guys want to go in a breakout room and work it out, I've got no problem. I don't have a problem.
Okay,
that's what the
fine.
two.
We can go to the breakout room because that's.
But wait until we're done. So you just have to be patient, Ms. Brown, and I'm going to recall your case, okay?
Okay.
Marion Manor versus Corey Running, 2502619.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Is he here?
Corey Running is not, Your Honor.
All right, go ahead and take a default on this, Ms. Cohen.
Okay, I just gotta find his file. Okay. Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor. The defendants failed to appear. I am requesting a default judgment. There's currently $1,064.52 owed in rent, $170 late fee, $176.54 in court costs, for a total of $1,311.06 with the writ to issue after July 24th.
Defendant failed to appear. Writ date will be July the 24th. The amount to be paid to save it from the issuance of the writ is $1311.06. So now all we have left is DeMonica Brown and Frank Duncan. And I think that's it for you, right? So I'm going to come back to Frank Duncan. Have you figured this out? Marion Manor versus Frank Duncan, 2502622. Mr. Duncan, your name?
Frank Duncan.
Have you figured out how much is owed?
No, because, you know, with all these fees that you're coming up with.
Mr. Duncan.
Oh.
I don't come up with any fees, and she isn't either. They're entitled to those by law. By law. I don't just sit up here and make up figures. Now, you're kind of agitating me at this point. I'm not going to put up with this nonsense anymore. I told you to figure out what you think you owe without the fees. I'm going to go on to another case, and I'm coming back then, and you're going to tell me. And if you don't, then I'm going to make a decision. Okay? You can go into a breakout room with Ms. Brown, and then when you're done with that, I'll call this one back here.
Your Honor, I have Tanglewood cases too that were.
I know you do. Why don't you go ahead and go in there, because I'm getting off the bench. I'm getting agitated right now. Marion Manor versus Frank Duncan, 2502622. All right, Ms. Cohen, your name?
Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Mr. Duncan, your name? I need your name, Mr. Duncan. You need to unmute. He was just sitting there. Mr. Duncan, you need to unmute. Bottom left-hand corner.
I know, this thing has a mind of itself.
Your name?
Frank Duncan.
How much do you owe?
Well, according to what I'm looking at here and what was said, that I'm trying to make sense of, it was right around $1,400.
All right, that's not a good enough. You would think you owe 1416. He owes 1416.54, right?
That's what we decided on.
The judgment will enter. I find you owe 1416.54. The writ date will be July the 25th. This will be after hearing. After hearing. So you have to pay that amount, sir, by July the 25th. If you don't, you have to vacate. If you don't, you're going to be evicted. Thank you very much. Have a good day, everybody.
I got a couple questions here. Do I have a right to appeal?
Yep, you got 10 days to appeal until July 24th. You can file appeals at court. If they disagree with you, you can ask the Court of Appeals to hear your case.
Okay. And do I have a right to a jury trial if I so decide?
Not at this point. There's no triable issue.
Okay.
Good luck. Tanglewood versus Bethany Jackson, 2502632.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Ms. Jackson did not check in with me, Your Honor.
Let's do a default here.
Your Honor, I'm requesting a default judgment. There's currently $1,013 owed in rent, $170 late fee, $176.54 in court costs, or a total of $1,260 with the writ to issue after July 24th.
Defendant failed to appear. Writ date will be the 24th of July. The amount to be paid to save it from the issuance writ is $1,260. Tanglewood versus Braylon Calhoun. 525-02633. Ms. Calhoun, your name?
Braylon Calhoun.
Good morning, Ms. Cohen.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Ms. Calhoun, did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
Yes.
You do? Yes? Yes?
Yeah. Is Ms. Cohan a lawyer?
I'm sorry?
Is Ms. Cohan the lawyer? I didn't get a chance to speak to her.
She's the plaintiff lawyer. If you want to speak to a lawyer from Lakeshore.
No, I don't need to speak to an outside lawyer.
Okay. Do you intend to apply for funding?
No.
How much is owed, Ms. Cohen?
There is $742.08 in rent, $150 late fee, $176.54 in court costs, for a total of $968.62.
Can you pay that amount, ma'am?
I can pay it in full by the 1st, but I can pay $400 Friday.
All right. Is that okay with you, Ms. Cohen?
Yes.
We're going to give you, I'm going to enter a judgment after hearing $968.62. If defendant pays $400 by July 24th, writ date extended until July 31st. You can pay by the 31st, right?
By the 1st.
By August 1st?
Yeah.
But you'll still owe August rent then. You understand that?
Yes.
All right. So you pay that balance by the 1st, but then you'll still owe August rent. Okay?
Yes.
Do you understand everything?
Yes.
All right. Just make sure you pay that $400 by the 24th. Okay? Good luck.
Okay.
Thank you. Are you done, Ms. Cohen?
Well, I'd like to address your late fee discussion for one short minute.
Sure.
I can assure you that when we get to court, that we do not charge more than $70 in your courtroom, because that's what you allow. Our lease does say $85. I understand that when we get to court, you don't allow that. There's nothing that prevents us from putting it in our lease, and it goes in on our demand for possession. And if they pay it, they pay it. And if we come to court, then we reduce the late fees. But I don't think there's anything in our lease agreement in the state of Michigan that caps late fees. And I understand that
There's not. And I wasn't necessarily talking about yours.
Okay.
I'm saying there are times when I get these and then when I inquire, the late fees exceed $70. And I'm only telling you, if that happens, I'm going to require the manager to show up as long as I'm sitting on this bench every time. So they better be careful. I'm not saying it's your cases. I'm saying if I catch somebody doing that because of negligence, and it happens.
Okay.
And I'm not going to have to, I shouldn't have to, everybody knows what my position is and has been, and I shouldn't have to babysit. And then when I find out, are there late, what the late fees are, and they exceed $70, it's number one, slows me down. Number two, it's beyond, it's contrary to my directive. And you're right. You're right. I don't know of any law that says that late fees in the state of Michigan are capped, but they are within the discretion of the judge to appoint based on reasonableness. And that's what my directive is. And I'm just telling you, and I was not referring necessarily to your clients. I was just telling you, I don't want to find out when I ask questions, when I get lawyers saying, Judge, the judgment amount is $32.73. That's $2,800 in $28.92, including late fees. And then I inquire what the late fees are, and they exceed $70. That agitates me. Now, I have every right to be agitated, because then I start to feel like when it's so well known what I've said, and I had 50 on there till about 6 months ago, that I feel like they're trying to pull one over on me. So if I've got to have them come in every time and tell me what they are, then that's what I'm going to do. That's all.
It just concerned me when you said we can't put it in our demand for possession.
I don't think I said it. You can't put it in your demand for possession. I said, I see that in the demand for possession, you've got $85 in late fees.
All right. Thank you.
I mean, I think it's nonsense if you're putting it in demand for possession. I don't think Judge Hessen takes a different position than me. If she does, you can tell me.
She does not limit her late fees in her courtroom.
Okay, well, this isn't my courtroom and that's not her courtroom. It's the taxpayer's courtroom. I never knew that. We did $50 a month for the longest time and then I increased mine to 7. So if she doesn't, she doesn't. That's her prerogative. And it's my prerogative to do what I'm doing. And I
Okay,
feel
all
good about
right. I just didn't want to, I just wanted to clarify things.
I got it. Thank you very much. Dear.
Then the next case I'll take, which is going to be a two-party case, is Adams versus Wallace. So, Mr. Wallace, would you come up here to one of the tables, please? All right, that'll be fine. Yeah, as long as the microphone picks up your voice, that's fine. The microphone's at the table. So he should be at the table, not in front of me. Yeah. Either table is fine. Yeah. Okay. Yeah, that's perfect. Yeah. All right. And this is 25-207. And Mr. Wallace, are you able to hear me?
Yes, I can hear you.
Okay. All right. So this is Miss Adams's petition for an anti-harassment order against Mr. Wallace.
Yeah.
All right. And Mr. Wallace, I see you got served with your paperwork on July 3rd.
Yes, that paperwork.
Okay. You got your paperwork there. Okay, good. Are you ready, Mr. Wallace?
Yes.
Okay, Miss Adams, are you ready too?
I am.
Okay. Now, Miss Adams, what I'm going to do here before we start is I'm going to swear you both in, and then Miss Adams will go first, and then Mr. Wallace will go second. I'll hear from both of you what you have to say about the situation and make a decision as to whether or not to issue an anti-harassment order. And Miss Adams is the petitioner. You've got the burden of proof to show the court by a preponderance of the evidence that you're entitled to this anti-harassment order that you're asking for.
Okay.
And keep in mind that anything that you have previously filed with the court is already part of the record in the case, and I've already seen it and read it, and so has the other party. So it's not necessary for you to repeat orally everything that you've already filed in writing. Okay, so can I have you both raise your right hands, please? And do you both swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
I do.
All right, Ms. Wallace, I'm sorry, Ms. Adams, go ahead.
So the reason that I'm seeking a petition is because first of all, Mr. Wallace accused me of stealing a watch, which I didn't steal, but that seemed to cause him great agitation that he thought that I stole it. And for 2 weeks, he literally would stay in corners. He would follow me around. And the thing that really upset me a great deal is that he went after my granddaughter and I. He physically went after my granddaughter, who was in a cart, and he shook it violently. He followed us. He wouldn't leave me alone. He followed us into the main area of the apartment complex where there was a great deal, many people there. And it was also caught on film that he kicked me. He would not leave my granddaughter alone. She's sick. She was terrified. And even if I can't get the restraining order for myself, I'd at least like to get it for my granddaughter because she's terrified of him now. And they used to have a really good relationship. But the fact that he was violent, extremely violent and angry, and I'm afraid of him. I'm afraid that he will come after me again. I'm afraid that he will come after my granddaughter again. So that's why I'm asking the court to grant us the restraining order so that we can keep things the way they are right now, where he stays in his corner, I stay in my corner, and I'm not afraid to leave my apartment right now because of the restraining order. But prior to that, I was afraid to go anywhere alone. I always had to have someone with me in case he antagonized me or came after me. And because of that, I'm afraid of him. And I don't want to go back to what it was, where he was violent and he was attacking me. I can't go back to that, especially with my granddaughter being there.
I need to ask you a couple of questions then, okay?
Okay.
Does your granddaughter live with you?
No, but I do watch her quite often. And so she's here at least 3 days a week.
And then you and Mr. Wallace live in the same
Apartment
building.
complex? Yes,
Is that the reserve?
it is.
Okay. So there are common areas out there too, right?
Correct.
Okay.
And the way
I don't
that
know.
he and I have been handling it now is if we show up at the same place, we just go our separate ways, which we've run into each other a couple times. And it's been nice because he goes his way, I go my way, and there's no interaction between us.
Okay. All right.
The
And
couple
I'm
of times that we've run into each other.
Okay. And it looks like when she issued the temporary order, Judge Wilcox kind of took that into account. All right.
Correct.
I wanted to make sure that there wasn't something about that situation I didn't know. Okay.
No,
Yeah, Ms. Adams, I know I interrupted you there. Is there anything else you want to tell me about this before I give Mr. Wallace a chance to tell me his side of it?
No, I think I've explained everything.
Okay. All right, Mr. Wallace, it's your turn, sir. What would you like to tell me?
When I first moved into the reserve apartments, she was my caregiver. I had money turned up missing. I had a debit card turned up missing. She supposed to buy food for me, but she was buying food for herself. She was paying her bills, her electric bill, her Amazon music bills with my money. She was paying for all these things. She stole my watch, my wristwatch from me. I tried to get my wristwatch back from her, and she would not give it to me. She took it, she dropped it down the front of her blouse and says, ha ha, I've got your watch, you can't have it, ha ha ha. Okay. And then she started stalking me. I'd go to the other side of the building, stay away from everybody and everything. She'd come. I have people that saw her do that.
Did you report those things to the police?
Yes.
All right, Mr. Wallace, is there anything I need to know? Anything else I need to know?
So I think that's it.
All right. All right. So yeah, a couple of things here. First of all, Ms. Adams, I'm not going to be able to write an order that takes your granddaughter in because only her parent can do that. Or somebody who has the legal authority over her to do that.
Okay, so her mom can do that if she chose to?
That's her decision.
Okay, thank you.
And, second, Mr. Wallace, I'm not making any decision here about whether she stole your stuff. That may have happened, it may not have. I don't know. That's not part of this case. But what is part of this case is whether or not Ms. Adams has made a case that you've been harassing her. And she is. Now, you may believe she took your stuff. Maybe she did. But, accosting her, effectively in her home, taking physical action against her, scaring her grandchild when she's with her. Those are all the kind of things that we call harassment. And they in this case, they have happened over a course of time, and it's a course of conduct. And it's reasonable for her to be concerned about that, especially when she's in the presence of her granddaughter. So you can't just do that, even if you think she took your watch. Okay, let the police handle that. This interaction between the two of you has to be peaceful. And I'm sorry if you were the victim of a crime, but that isn't established, and it's not an excuse for the kind of behavior that she's describing here. So I'm going to issue the order. It's going to be on the same terms and conditions as when Judge Wilcox issued the temporary order, and it's going to be in effect for the next 6 months. All right, this order will be in effect until January 15th of 2026, which is 6 months from today.
Okay.
All right, Mr. Wallace, since you're here, we'll give you a copy of this order. And Ms. Adams, the court clerk, will email you yours before the end of the
Okay.
day.
That sounds great. Thank you.
Thank you both.
Is it okay to leave?
Yep, it's all done for today.
All right. Thank you so much.
Yes, sir.
Okay, cool. Now I need to smoke because that
Stories
really.
that she has told are not, a lot of them are not true. She has stalked me. I don't stalk her. She goes around the building looking for me where I'm at, and she stands there and harasses me. Her boyfriend threatens to shoot me. He goes like this: I see you, bam, bam, bam. What he does to me.
All right, ma'am, would you mind picking this up for Mr. Wallace? Thank you. All right, and that'll conclude
I'm
your
89
hearing,
years
Mr.
old. I just
Wallace.
want to live in peace. I don't need this harassment from them.
All right, that's all for today, Mr. Wallace.
You should have known they'd protect her.
Okay, now next
Get me
will
out of
be Danielle and Brian Johnson versus Kelly Phoenix. Okay, all right, and Miss Phoenix, I see that you were served with the notice of the hearing on July 8th. Are you ready to go?
Yes.
Okay. All right, thank you. All right, and so same thing, I'm going to swear the parties in here. The Johnsons are the petitioners here, so they're going to get to go first, and then I'll hear from you, Miss Phoenix, and make a decision, okay? All right, so can I have all you raise your right hands, please? And do you each swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Okay, so I'll hear from the Johnsons first.
Okay. Do you want us to start? I know you have all the paperwork. Do you want us to start from the beginning, from the 2 years ago, or 2 years of this?
Well, it's really up to you, but you know, do keep in mind that I do have your whole petition here, which is made part of the record, and I'm aware of it.
Okay. So basically, you know, this has been 2 years ongoing with Kelly. She was a member of the gym. She started stalking our grappling instructor, Paul. He is a lawyer, by the way. She sent, you know, over 100, like 125 emails to him during the day. So we had to let her go out of his class. And when Brian would explain it to her that she can't take it because of her mental illness, you know, she's diagnosed schizophrenic and she has psychosis. I've also talked to her two sisters, one that she lives with that says she doesn't take her medications, and her estranged husband, but she was under the impression that Paul had this thing for her, as she did with everybody else in the gym, telling Brian, well, you don't see it, you don't feel it, you don't see that energy. And Brian's like, no, you know, he does not want you in the class. Like, she was just, it was just too much. And so she kind of just stayed to herself in the gym, walked on the treadmill. And then soon after that, she had in her mind that Brian wanted to be with her. And that's why Brian kicked her out of Paul's class. And then she started in with Brian. And so Brian we had to kick her out of the gym because it was just, she was just getting crazier and crazier. So you see all the stuff that she did. She sat behind his car several times when he was leaving the gym, sent him flowers, sorry. All those texts, emails, trying to get together, trying to have drinks. She did that also to a couple other guys in the gym. Then it kind of died down a little bit. She put a horrible email out, or a text, or sorry, a Facebook message that you have a copy of that, that she took down after I confronted her with that, but it got out to members. And then she kind of died down for a while until a couple of weeks ago, where she started sending out those emails about those horrific things about our daughters, Brian, and then the second one stating that Brian and I did a murder to hire here and all this crazy stuff. And we have all the proof for that. We're just doing a civil suit on that part of it. But what we're concerned about, and also the police officer in South Carolina states because of her mental instability, he's concerned her blasting these emails out to businesses and members that somebody is with our addresses, our kids' names, that somebody is going to believe some of that stuff, and they're scared for our livelihood or what's going to happen to our business. And Kelly has said about 5 months ago, her estranged husband said she was going to come back here, and she has it in her mind that she is welcome back into our gym. And so our members are afraid. Our kids are afraid of her, because she's not well. And we're just trying to protect that. And I, if she does come back here, I don't know why she would come back here. Her estranged husband and kids both have restraining orders on her, so she doesn't have anything here. But being her mental illness, I just don't trust her at all with what she's capable of doing. And then her husband, we have a letter from him to ex-husband, or soon to be ex-husband, said that she was trying here to get a gun. She really wanted to get a gun. And he was afraid because how she was talking about me, because, she thinks that Brian wants to be with her and I need to be basically removed from the situation. So that's about all, but you have all the rest. So we're just really afraid of what she might do or what she's capable of.
And Mr. Johnson, did you want to say anything as well?
Just, that's pretty much it, Your Honor, in a nutshell. Just, she's shown up to our gym after I've removed her from the gym, blocking me in behind my vehicle. I've taken pictures of that. She's been sending me flowers, emails stating that she thinks that we have this thing between us, which we don't, which I don't understand, because she's never really been in my groups in my gym. She's been with everybody else, and how this turned from my grappling instructor to me, I just can't fathom it. I don't understand why she's doing this. And she's done this to a couple of my other members of my gym, that she's wrote them letters and emails and so forth. And these are married men. And finally, I had to remove her from my gym. And then that's when the hardcore stalking started, where she was showing up behind my vehicle at 9 o'clock at night, blocking me in. And I called Lacey PD when this happened way back. And they were saying, get a restraining order. I should have back then. I thought it was going to go away. And then the crazy Facebook post stating that I broke into her house and put video surveillance cameras in her house. I put trackers on her phones. Then the final one is she's emailing all my sponsors to my Northwest Fight Challenge event and all the members of the gym, stating that I raped my kids and that I raped all their friends. And then she's stating, and she wrote another email out to everybody, blasting it out again, that my most favorite, that I've confided in her, that I'm raping, and my most favorite is my adopted sister, which I don't have an adopted sister, but she's putting this crazy stuff out there that my favorite person I'm raping is my adopted sister, which I don't have, and so forth. But I mean, it's just, I fear for my wife, myself, my kids, members of my gym, that this lady that it clearly has mental issues is going to show back up here in the state of Washington every day since I've removed her from my gym. When I open my door to leave the gym, I scan the parking lot looking to see whether or not she's going to be around the corner with a gun, that, something bad's going to happen to me or my family, because if she can't have me, nobody can. Or if she removes my wife from the situation, then we're going to have whatever she thinks in her delusional mind that she's going to get. I just want her nowhere around us because she's unstable, and I just want to feel safer in our business, our home, from this lady that's clearly mentally ill. And so, and you have everything there that she's been doing, the emails, everything, and she's blowing my home address out to emails to people. Like my wife was stating, if one person believes this, are they going to come and try to burn my house down? Are they going to try to do something bad to me or my wife or my kids because they're going to believe what she's stating in these emails, that she's putting my personal address and my kids' name into? I just want it to stop, and I want her to be away from us, and a restraining order will restrict her from, there's consequences if she disobeys a restraining order.
All right, thank you both. Okay, Miss Phoenix, it's your turn to tell me your side of it.
Okay, deny or refute a lot of what they said. It's outright false or wild warped exaggeration. Now, I did file a mutual restraining order against them. However, unfortunately, it was not there in time. I think I filed it. I sent it to the wrong email address. You may have some things I've already submitted So I do have a mutual restraining order request on both of them. And I also have a police report made over years ago. So when I joined this gym, it was in 2015, and he kicked me out of his gym in 2017 as a direct result of having rejected his sexual advances towards me. And so a lot of this happened a long time ago. I deny any kind of stalking behavior. In fact, I have accused him of stalking me, and is why I had to leave the state. He clearly admits to having called my family, my husband, completely inappropriate. He has information and inaccurate information about that. He's also been the one posting things on his business's Facebook page. The petition I have submitted and will submit a more thorough one today at the correct email address will show the evidence that I will submit about things that they posted, things that they texted as well. Danny Johnson called me, threatened me. Brian Johnson threatened me as well. I prepared a statement to a declaration in response to this, if I may read that.
It's your decision.
Okay. Okay. I declare that I've never stalked their employee, which was one of their claims, and certainly not continuously. The employee that Brian Johnson is presumably referring to is Paul Boudreau, who is Brian Johnson's jiu-jitsu instructor, as well as his personal attorney. Paul is also my former jiu-jitsu instructor. Now, Paul was the one who kicked me out of his class after I was in his class for almost a year, and it was through personal issues with him and I. It was not Brian who kicked me out, it was Paul, and not as a result of stalking or inappropriate behavior. He thought I was disrespectful to him in class. Regarding the statement that I sat in behind my vehicle and behind Paul's vehicle and waited for him. On roughly 2 occasions upon leaving this gym for the night after that jiu-jitsu class ended in 2015, every weekday, Paul Boudreau was actually the one who started sitting behind my car several times at night. Now, I didn't think this was stalking or inappropriate. I just assumed this was chivalrous kind of behavior because it was dark. But we never talked about it. And so I did the same to him on only 2 occasions, mind you. But this is certainly not an example or evidence of me stalking him. But in Brian Johnson's own petition, he clearly admits that he inappropriately contacted both my husband and my lawyer, as well as my sisters, after I had suffered a nervous breakdown. As a result, I believe was their stalking of me, not only stalking me, but defaming me and slandering me in the whole community there, such that I felt the need to flee that state. I plan on finally be able to afford to hire a lawyer and subpoenaing some poor witnesses and having a civil case against them and having this finally proven. But I have not been able to afford that. My divorce settlement is next month. I will be returning to Washington then. Hopefully, I'm anticipating having some funds in order to do this.
It's like we just lost Miss Phoenix's connection. All right, we'll stand by for a minute here. There we go.
I'm sorry, my phone cut off. May I continue?
Yeah, we just lost you for a couple seconds there, so you can pick up where you left off.
Okay. In his own petition, he clearly admits that he's inappropriately contacting both my husband and my sisters, getting information from them. I did have a nervous breakdown a couple years ago. I had never had any mental issues prior to that, certainly not when I was a member of their gym. And the diagnosis, which I refute, I believe is erroneous and ultimately was defined as related to marijuana usage, which I no longer even use. It's not legal in South Carolina. I have not used that for a while since moving here. I've made 2 separate police reports about the stalking behavior by Brian Johnson, but unfortunately was not able to obtain the copies of those reports in time to include with this response. I was actually hoping to have an extension, if that's possible, for evaluation of these what will be mutual petitions for protection, restraining orders. I've also submitted my own petitions for protection. They were filed this morning. Apparently, I sent an email. It's the wrong place, though you may have some I did file correctly a couple days ago. I suspect that the main reasons they have filed this petition, which I'm not even in the state, I don't understand why they think I've been stalking them. I certainly never walked far. So I suspect that the main reasons they filed this petition, is to attempt to thwart me pursuing further legal action against them, both civilly and criminally, as in the protection order, there was a request to prevent me from engaging in any further legal action against them. It behooves them to make me look insane as defense and distraction from my own old as well as ongoing accusations of their stalking of me. It is a very timely action of theirs, as I will be returning to Washington next month to finalize my divorce for my husband. And I feel threatened from Brian Johnson and Danny Johnson, both of them of which have threatened me. As I've long suspected that Brian installed or had someone install stalkerware or spyware apps on both my cell phone and laptop that I left unattended in his gym, they would have been privy to this information. I'm anticipating receiving money for my divorce settlement, at which point I will finally be able to hire an attorney to subpoena some critical witnesses that can corroborate a definite pattern of defamation that Brian has been applying to me in retaliation for having rejected his sexual overtures towards me. His being rejected by me is why Brian Johnson kicked me out of his gym 1 day after I had rebuffed him. I definitely do not believe that I'm welcome back in his gym, nor do I want to be. I never want to be in that place again, or see him, or see any of them. I suspect Brian Johnson to be a predatory, malignant narcissist who has a definite warped sense of reality and gaslights everyone. He is a former part-time Tumwater, Washington police officer. The day after he prematurely ended my gym contracts, I went back to his gym to attempt to speak with him. He'd been very upset and he kicked me out. When I did so, he threatened me with the, quote, dossier that he had told me that he had been compiling against me. Very private information from my life that he should not have known, which led me to speculate that he still has and abuses access to the private confidential information in the Tumwater Police database. I've never signed John back to his gym on occasions to attempt to talk to him in his situations. And again, that was in 2017. And though I was not interested in him, I'd been friendly with him. I sent many emails to him following being kicked out of his gym. I sent a lot of emails to Paul, but that was throughout the year I was his student, not afterwards. And I have not since sent any emails to Paul Boudreau. So this was about 7 to 8 years ago. I've not sent any emails, called them, seen them, or made contact with them since then. As my husband and I have been engaged in an acrimonious custody battle and prolonged separation, my husband was able to acquire sole custody of our kids through duplicitous means. I was never a threat to my children. It had nothing to do with any mental health issues. It was ultimately a misunderstanding, and it's something that I hope to rectify very soon in my divorce settlement. I'm not sure what emails Brian Johnson is referring to. And also, when I received this petition, I didn't receive any kind of, I don't know what it says he attached some evidence to his case, but I didn't receive anything like that. And I had been under the assumption that that had to be included. So I seek for a continuance of this when I have all of my paperwork ordered.
All right. Thank you, Ms. Phoenix. All right. I'm not going to grant a continuance. I was clear in the beginning. I asked the parties if they were ready to proceed, and all the documentation was filed with the court in a timely manner. So I don't see any reason why any exhibits or any other documentation wouldn't have been available to the parties well in advance of today's hearing.
Sir,
So, yeah, Miss Phoenix,
when
I'm
you
gonna ask you
asked
not
that
to,
question, okay,
Miss Phoenix, I'm gonna ask you not to
okay,
interrupt, okay? I'm gonna actually insist on that. This is the part of the case. Now I've heard both
okay,
sides. I'm gonna tell you my decision and I'll explain why I made it. That's not an invitation for you to
okay,
interrupt or argue, okay? If you do, I'm gonna have the
right,
clerk mute your microphone and that'll be your end of participating in the hearing. Clear enough?
yes,
Okay. All right. So the parties have presented their cases. The Johnsons are the petitioners with the burden of proof to show by a preponderance of the evidence they're entitled to the order that they have asked for. And they, in my view, based on the testimony that they provided today and the exhibits that they provided as well, that this is clearly a case where they've established that stalking has occurred. They've supported that through their testimony as to the actions of Miss Phoenix. They've supported that through the various letters and emails and other forms of communication by Miss Phoenix that they have found to be upsetting. Those things have gone on over a period of time. They're targeted at the Johnsons. They clearly express a desire that the Johnsons should be placed in fear for their safety, not only from Miss Phoenix, but from other people that she is attempting to create the impression that the Johnsons may need to fear as well. This is all obviously coordinated or linked in a way to make the Johnsons feel intimidated and scared at all times. And based on their reaction to the various kinds of communications, they have been scared. And a reasonable person in their position would be scared based on the actions that Miss Phoenix has taken. There's no lawful purpose to any of this. The only caveat I'll say in that is that if there's any litigation related to defamation or what you folks have referred to as libelous statements or slander, that's beyond the scope of this court's jurisdiction in this matter, and that would have to be decided separately in a different kind of legal action in a different court. So I'm not making any pronouncements about the validity of any kind of defamation or whether any of that's actionable. I will therefore grant and enter a stalking protection order protecting the Johnsons. And I'm going to place that order in effect for 5 years. All right, I've signed the stalking protection order. As I've indicated, it's been reduced to writing and it will be available to both parties. The court clerk will send you each your copies.
Thank you so much.
Thank you, Your Honor.
Okay, you're welcome. And that'll end the hearing for today.
We will go on the record in the matters 24 CF 105, 24 CF 112, State of Wisconsin versus Noah Gosman. The The state appears through District Attorney Kevin Schmidt in person. Mr. Gosman appears in person with counsel Nicholas Davis. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. We are in victims' rights compliance, correct?
Yes.
Mr. Schmidt, excuse me, Mr. Davis, can you please recite the agreement for the record?
Your Honor, I would, if you'd allow me, I'd have the district attorney put the agreement on the record, please.
Yes, Mr. Schmidt.
Mr. Gosman is going to be entering a plea to 3 counts. The counts are going to be 1 count of the H felony, person who volunteers or works with children, has sexual intercourse with them, and then 2 counts of the misdemeanor person over the age of 19 has sexual intercourse with person 16 or older.
And 2 misdemeanor counts, you said?
Yep, they're all in the complaint.
All right, and so it'd be like count 5 and count 5 and then count 10?
Yep, the idea is you can probably guess is 1 for each instance of sexual intercourse. The agreement is 2 years probation, the misdemeanor, 5-year DJOC, and the felony. The felony requires a sex offender evaluation and follow through. No contact with minors unless they're related by a blood or family.
Okay, all right, basis for the agreement that's reached and why it's in the public interest?
Yeah, Judge, a lot of counts are being dismissed because the police investigated 3 crimes and referred charges for 3 crimes. This person who works or volunteer with children having sexual intercourse, the evidence of what the police investigated is strong. The victim and the defendant admitted they had 3 instances of sexual intercourse. They described when it happened. The victim was tracking it on some sort of app on her phone, so we had specific dates. It occurred at the driving parking lot of the subway in Siren. When they sent it up, the former district attorney added a whole bunch of other charges without consulting with police. Many of the charges lacked probable cause. The child enticement counts lacked probable cause because in all 3 instances of the sexual intercourse, they did not relocate once it was initiated, and it was an extremely public location rather than a secluded one. The contributing delinquency of a minor counts alleged that the victim NJ committed the crime of exposing herself to the victim Noah Gosman, which made no sense. The misdemeanor sex assaults, 2 of which he's pleading to, are actually lesser included of the felonies under the Blockberger test. I confirmed that with DOJ before reaching that conclusion. So that's why we're kind of mixing and matching that there. The exposing to a child, I guess technically works. I think you can charge that in any case where someone has sexual intercourse with them. It just kind of misses the mark of what the case is about.
Okay, all right. And so that's the agreement that you've reached, Mr. Gosman?
Yes, it is.
And you fully understand the agreement that you've reached?
I do.
All right. So we do have 2 people, 2 victims who are going to be making statements here today. I'm going to take the statements first. I do have one by video. Oh, she's not. Yeah, she's here. Yes. And I think she said NN. You can please state your name and give me a statement, please.
I do not wish to make a statement.
All right, so no statement. All right, so Ms. Bauer, the other individual, please. And when you get to the table, you can either state your name for the record or your initials, whatever you prefer. All right, you may have a seat. And then please let me know how you are related to the case and what it is that you would like the court to know.
I am the stepfather. What I would like to address the court is the impact that this has made. It started as a 16-year-old daughter who had dreams becoming a registered nurse. She was enrolled into Pine Tech. She was gonna do as much as she could in schooling there, then go over to Ramsey and finish out her RN. Since this has all started, she can't show, she doesn't feel comfortable showing her face. She has dropped out of school. She got as far as a CNA and she moved away from Grantsburg. found friends that would take her in, made new friends and not good friends by all means. But 18, there's nothing you can do at this point. Has spiraled downhill. Has a hard time holding a job. Most likely probably be getting her car taken shortly. Can't make payments on anything. And she was a very good person, a very, very, well, she was a nice child. She was never had issues with school, and when she did have issues, she got help and she overcome it. She always wanted to follow in her mom's footsteps as an RN. That was her goal. It was to help elderly people, be in that scenario. And since then, she don't even go out in public. She don't want anything to do with people in general. Just like I said, she just spiraled. This whole thing has impacted me and my wife. We've had issues on how we should handle things. You've seen her here more than you've seen me, because I don't handle things very well. I can get very irritated fast. The manner of which of this is, I try to stay away and distance myself as much as possible. Otherwise, I'd be in court here too. That really wasn't how I wanted to play this out. Where we were from the very beginning to where we are here, this is what you guys do. Do I feel it's just as a father, as a stepfather, as a husband? No, I do not. Do I think there should be some jail time involved? Probably. This guy used his bus driver to get close to a child at 16 years old started. He used his cop as a Wisconsin police officer at one point to manipulate this child all the way up until she was 17 and 10 months, 11 months, whatever it was. So, I mean, it just hasn't been going on for just a short period of time. There was a point in time where me and Nicole stepped in when she was 16 and told this gentleman to stay the F away from our kid. So he knew he was doing something wrong. He held the badge to uphold people from doing something wrong like this. And I think he's getting off pretty easy. I don't know what else to say. I really don't.
All right, I appreciate that. Thank you, Mr. Nelson. Let me go have a seat. All right, before we begin, I did look at the plea questionnaire waiver of rights form. It is not signed by Mr. Gosman. And while I'm waiting for the signature, NN, are you sure that you do not want to make a statement?
Okay.
I'm sure. I think Mike was very clear that this was occurring way before. And did a pretty good job.
All right, thank you. Thank you, Mr. Davis. So I have in front of me a plea questionnaire waiver of rights form along with the deferred judgment of conviction document. Mr. Gosman, do you recognize these documents?
That's what I
Yes.
signed. Yes.
Did your attorney thoroughly go over these documents with you?
Yes, he did.
That is, did he essentially read them word for word?
Yes,
And you understand everything on these documents?
I do.
If by chance you didn't understand something, did you ask your attorney to explain it?
Yes,
And he did so until you understood it.
yes.
And on the second page of the plea questionnaire and the third page of the of the deferred judgment of conviction document, are those your signatures?
Yes, they are.
So you're telling the court that you went over these documents and you fully understand everything?
Yes,
You are pleading guilty to two misdemeanor counts in the 24 CF 105 of having sexual intercourse with a child 16 or older, actor 19 or older, 19 or older, excuse me. Okay, I'll repeat that. So you're pleading guilty to two counts of misdemeanors of sexual intercourse with a child 16 or older, where the actor is at least 19 or older. Is that correct?
Yes.
And you're pleading guilty to one felony count, and that would be to the sexual assault of a child by a person who works or volunteers with children, an H felony. Is that correct?
Yes, it is.
You're 32 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that correct?
That's correct.
And your attorney thoroughly went over with you those charges that you're pleading guilty to, as well as what the state would need to prove your guilt beyond a reasonable doubt?
Yes, he did.
And did your attorney go over with you the maximum possible penalties you face?
Yes.
You are not receiving any treatment for mental illness or disorder, no drugs, alcohol, or other medications, correct?
That's correct.
I do not know why my voice is getting harsh or hoarse. Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on the document. Do you understand those rights?
Yes, I do.
Did your attorney thoroughly go over those rights with you?
Yes, he did.
And you understand them completely?
I do.
Do you need me to go over those rights with you in any more detail?
No.
You understand them completely?
Yes, I do.
And those are the rights on the first page of the plea questionnaire, as well as the deferred judgment of conviction document. Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Do you understand that as to that felony count, count 2, sexual assault of a child by a person who works or volunteers with children, the state would have to prove on or around April 11th, 2024, in Burnett County, Wisconsin, you had sexual intercourse with a juvenile, victim 1, date of birth, May 26, 2006. A child who has not attained the age of 16 and is not your spouse, and with whom you work with or interact with through your occupation or a volunteer position. Do you understand what the state would have to prove? You may ask your attorney a question.
And it's supposed to be 18, correct?
Your Honor, what he conveyed to me is he believes that the child had reached the age of 16. When this occurred, she was.
Mr. Schmidt?
What's the question?
The count says a child who had a, she had. I will repeat that.
Yes.
What the state needs to prove is on or around April 11th, 2024, you had intercourse with a juvenile victim, 1, date of birth, May 26, 2006, a child who had attained the age of 18 and is not your spouse, and with whom you worked with or interacted with through your occupation or volunteer position. Do you understand what the state would have to prove?
I think the confusion the court keeps saying is had attained the age of 18. It's has not.
Is it has not or had?
It has not.
Has not, yes.
I am reading exactly what you charged.
That needs to be changed then.
Count 2, a child who had attained the age of 16.
Yes.
I read
Yes.
it exactly from.
I concur with that. You're right. That's, yeah, she had attained the age of
So
16.
she is over the age of 18. She's 16 or older. Is this the charge that he's pleading to or not?
It should be count 2.
That's what I read.
The court, because the criminal complaint says 16. What are you reading?
I'm reading the criminal complaint that says a child who had attained the age of 16.
Yes, you were saying 18 in the colloquy. That's been the confusion.
All right, did I say 18? All right, I apologize. Again, count 2, sexual assault of a child by a person who works or volunteers with children. The state would have to prove on or around April 11th, 2024, in Burnett County, Wisconsin, you had sexual intercourse with a juvenile victim, 1, whose date of birth is May 26, 2006, a child who had attained the age of 16 and is not your spouse, and whom you worked with or interacted with through your occupation or a volunteer position. Do Do you understand what the state would have to prove?
Yes, I do.
Do you understand that the maximum possible penalty of this H felony could be a fine of up to $10,000 or imprisonment up to 6 years or both? Do you understand that?
Yes, I do.
All right. I am looking at my notes and I said 16, but. All right. So you understand what the state would have to prove and those maximum possible penalties.
I do.
Count 5, sexual intercourse with a child. The state would have to prove on or around April 11th, 2024 in Burnett County, Wisconsin, you did have sexual intercourse with a child, juvenile victim 1, date of birth, May 26, 2006, who was not your spouse and who had attained the age of 16 years, and the actor, you, had attained the age of 19 years or older. Do you understand what the state would need to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of not more than 9 months or both?
Yes.
And do you understand, so you understand what the state would have to prove and that maximum possible penalty?
I do.
And with regards to count 10, which is essentially the same charge, but a different date, it alleges, and the state would have to prove on or around April 18th, 2024 in Burnett County, Wisconsin, you had sexual intercourse with a child, juvenile victim 1, date of birth, May 26, 2006, who was not your spouse and who had attained the age of 16 years, and you had attained the age of 19 years or older. Do you understand what the state would have to prove?
Yes, I do.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
I do.
Do you also understand that there is an agreement reached by the parties here, a joint resolution, whereas you would plead guilty to these 2 counts of misdemeanors, and that you would plead guilty to that H felony, and with the misdemeanors, the court will put you on probation, and with the deferred judgment of conviction, that would kind of hang out there for a period, I believe it was for 2 years,
Yes.
60 months, for 60 months. So for 5 years, it will hang out there, and if you violate those conditions, then this agreement will be revoked and you will be in front of the court for sentencing on that felony charge. Do you understand that?
Yes, I do.
Do you understand that this is the agreement of the parties and I'm not bound by that?
Do you understand that?
That in reviewing the facts of this case and your history and your characteristics and the need to protect the community, if I think that a different sentence should be rendered in this matter, do you understand that I can do that even if it's to the maximum possible penalty?
I understand.
Do you still wish to proceed and enter guilty pleas here today?
Yes, I do.
Did you go over the criminal complaint with your attorney? And that is that document that basically says what happened those days and why you were charged with these crimes?
Yes.
For the most part, are those facts accurate?
For the most part, yes.
So you're admitting here today that you did have sexual intercourse with a juvenile who had attained the age of 16.
We stipulate that happened. The defense stipulates to that.
All right. Mr. Davis, did you thoroughly go over the facts alleged in the criminal complaint with Mr. Gosman?
Yes, we've gone through this quite a bit, a lot actually. So he's aware of everything.
Understands those facts that are alleged
He does, Your Honor.
and what the state would need to prove in relation to the facts?
We actually went through the jury instructions themselves, so he understands, Your Honor.
All right, thank you. May the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, the defense stipulates.
Has anyone made any threats or promises for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
I am.
and voluntarily?
Yes.
Are you pleading guilty to these charges because you are guilty?
Yes.
Did your attorney represent you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
I believe so.
Has he went over with you the potential defenses you could have or a lack of defenses you could have?
Yes, he did.
Did he discuss with you the evidence in this case attained through discovery and what the state would need to prove your guilt beyond a reasonable doubt.
Yes,
And so, are you satisfied with your attorney's services?
I am.
Do you have any questions for this court or your attorney before I proceed?
No, I do not.
As to that felony count, a deferred judgment of conviction is being offered to you. If the court accepts it, do you understand that you wouldn't be under this felony restriction, but if the court does revoke it later and you're sentenced, you would be, and that means you would no longer be able to use or possess a firearm for life.
I understand.
You would no longer be able to vote in any election until your civil rights are restored.
Yeah.
And you understand that thoroughly.
I do.
Now,
He also understands that because the nature of the offense, that he would never be able to work or volunteer with children, anything like that. I went through that with him too, Your Honor.
all right, because he would, has there been a discussion on the sex offender registry?
Yes, I believe at this time I believe the state's not making such request.
All right. Do you understand what it means to have a dismissed but read in charge?
I do.
And do you understand that with all of those counts that are being dismissed and read in, I could still look at them with regards to sentencing?
Yes.
But I cannot go beyond the maximum possible penalty for each of the charges. Do you understand that?
Yes, I do.
Do you wish to proceed and enter a guilty plea?
Yes.
And Mr. Davis, you thoroughly went over everything, the strengths and the weaknesses of the case with your client.
Your Honor, we met in my office multiple times on that. We certainly did.
And do you believe that he is entering his plea here today competently?
I believe he is, yes.
And do you believe he understands that he is giving up his constitutional rights here today and what that means?
He does understand that, Judge.
And do you believe his pleas done today have been done freely, intelligently, and voluntarily?
I have put no pressure on him. No one has put any pressure on him. He is doing this on his own free will. Thank you.
All right, thank you. Then, Mr. Gosman, as to count 2, sexual assault of a child by a person who works with or volunteers with children, a class H felony, how do you wish to plead?
Guilty.
As to count 5, sexual intercourse with a child 16 or older, actor 19 or older, an A misdemeanor, how do you wish to plead?
Guilty.
As to count 10, sexual intercourse with a child 16 or older, actor 19 or older, an A misdemeanor, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of all 3 counts. As to count 2, the court will hold that with a deferred judgment and hear arguments on that, at least at this time. With regards to the other 2 counts, a judgment of conviction will be entered today. Argument and the other matter is dismissed and read in as well. Other matter, I said that, argument and sentencing recommendation, Mr. Schmidt.
Thank you. As I articulated for the public interest, this complaint should have been 3 charges at the start. The 3 charges should have been that person who volunteers have sexual intercourse. This is an optimal resolution for this case for a number of reasons. One, the nature of these convictions and this adjudication of guilt in this DGOC will have a large effect on Mr. Gosman, not just because he doesn't have a criminal history, but because given what his past work has been and what his goals for future work, it's going to have a severe effect on choosing his future employment and those sorts of things. The very nature of this, the connection to the NCIC with the arrests when anyone runs a background check, is going to make sure that he's not going to be in a position where he could potentially engage in the sort of behavior that I think you heard the stepfather talk about today. What we're doing here today, why aren't we arguing for any incarceration? I don't think it likely Mr. Gosman's going to reoffend based on his age, based upon his lack of criminal history, and just given the specifics of this case. This is a case where at one point in the past 2 or 3 years before 2024, Mr. Gosman was a bus driver for the victim in this case. She came to know him and consider herself her friend of his for about 2 years before that. According to her, she asked him out when she was 17 years and 9 months old. According to her, they had sexual intercourse 3 times, as described in the complaint, when she was 17 years and 11 months old. Mr. Gosman, because of his history and his past employment, obviously knows it's 18 in Wisconsin. If he had waited a month, there'd actually have been no crime at all in this case, and he didn't. This was a case where the victim was very clear it was consensual. I think by the time she even talked with law enforcement for the interview, she might have already been 18. Right now, she's 19 years old. She is not a girl anymore. She's an adult woman. Back then, she was very close to being an adult woman. And even in the interview, she shows a level of maturity that kind of makes us different from the types of cases where we're talking about young, like 13, 14-year-olds, that kind of age range, where you're imagining the very difference in like the psychological development. This was a person who was much closer to the adult end. And in fact, when the police were interviewing with her, they had to be clear she wasn't in trouble. She thought she was being attacked because she didn't even comprehend that any of this was wrong. She was talking about like marriage and moving in with Mr. Gosman. And it was a very different view of this case than I think what the law recognizes in Wisconsin. So I think given the age of that victim and the past history and this new conviction being the only convictions he has, I think this is the best way to make sure if there are any sex offender things with both the requirement in the DGOC and the probation, it's going to be dealt with. I think if he does reoffend in the next 5 years, it gives a huge hammer for the court to deal with that then. I think right now we're looking at him as a person who really made an extremely poor judgment call with someone who is, despite being close to 18, a large enough age gap where there should have been recognition that that difference in life experience can be very significant in understanding and control and things like that in relationships, specifically when you get down to those teenage years. It's very different than say like a 10-year age gap with someone who's like 50 and 60. So I think this recognizes the morality of that while also appreciating what laws were broken. Thank you.
Thank you. Before I get to you, Mr. Davis, I want to make sure, Mr. Schmidt, that I heard you correctly. You indicated that he's pleading guilty to these 3 charges, and these 3 charges should have been the only charges initially charged. Is that what you stated?
Yep, the child enticement counts and the contributing delinquency of minor, those don't even have probable cause. So I think those would have been dismissed before the defense even started at trial. I wouldn't even have gone to trial on those.
And for record, you weren't the district attorney who filed this. I just want to make sure that that's clear. You are now the district attorney and you have reviewed this, and in your review, that's your conclusion.
Correct. And these 3 counts are the 3 counts law enforcement recommended to begin with. No others.
All right, thank you. Mr. Davis.
Thank you, Your Honor. So I think that any conviction is serious offense. I don't care the argument that it's a misdemeanor, it's a lower level felony. That doesn't pass my mustard. If you're convicted of a crime that's serious and it's going to affect a person's life going forward, I'm sure that we've been involved with people that have a rap sheet that goes a mile long. They probably don't care if they pick up an extra misdemeanor felony, but in this particular case, this is extremely serious for Mr. Gosman. He has no criminal convictions at all. Now he does. He's got it deferred for very, very serious, and the other 2 are very serious as well. I would like I think that how they met is a little bit different than what the state is. My client was a volunteer, did do the bus driving for the school district, but he never drove her on a bus. He never drove her route. My client has a son, and I think he met her through the interaction because I think she helped his son as a young kid walking his son to the bus. And that's how they, I think, made their contact with each other. But eventually they did have contact, but he never did drive her bus route or drive her on a bus. But in any event, my client, I just want to start off, he made just a poor decision. And it's difficult to make this argument because usually I have some reason or justification, but in this case, he just made the wrong decision and there's no way to argue around it. And that's why we're here today. My client, he has a 6-year-old son. I think what's been difficult for him is that he is a widower. His wife is, or his ex, I should say, she is dead, so he is raising the child. And I think what happened here is he was getting attention from someone, a very intelligent woman. She was a minor, of course, but and he had interactions with her. She was positive. She was friendly. My client never entered into anything thinking as this is a relationship, but it did morph into that. And unfortunately, it morphed into something where he's now here pleading guilty to 3 convictions. I also want to say that my client has never met her parents or never had any interaction with the parents, the Nelsons, because I've gone through this over and over, and he never has spoken with them or met with them. But he does apologize for the situation or for what is now, what I heard today is wreaked havoc in their family, and that's not good, especially for someone who is so bright. And I don't like hearing that it affects someone's marriages. This is all around not a good situation. For that, I apologize, and my client apologizes. Whether the Nelsons will accept that apology, I would like them to know that my client is not trying to groom children or go after children. And he wishes this never would happen. And I hope that they can, in the future, at least believe that. They don't have to accept the apology, but at least they would believe that I would appreciate that too. And I feel sorry for the whole entire family. So I would like my court to know that the character of my client, he does not have a criminal record. And Your Honor, we did get him, he did do the sex psych evaluation, and we got on that immediately. And again, I know that Attorney Schmidt was not the district attorney at the time. I will re-provide that evaluation. I don't know if Mr. Renicky looked at it, read it or not, but we will make sure that that is to the DA's office immediately again. So he did take responsibility for that. And make sure that, and when I read it, Judge, there's nothing nefarious or anything that leads me to believe that he's going to have a high level of recidivism. I would like to make some points on this that the state made. These convictions are going to affect him, and so it should. Since he committed these crimes, he will never ever be in law enforcement, and I am pretty certain that he will never have any job with children again. It just will never happen. I mean, it's not just through the courts, but they've got administrative actions through the state of Wisconsin and other states too. So he has completely made sure that he's not going to have that career path again. He is going to have to raise his son, but it's going to have to be something other than what he did in the past. But I'm sure he'll do that. So he is laser focused. He's not someone that uses drugs or alcohol. I'm not saying he doesn't drink, but he doesn't abuse alcohol. He does not use drugs or narcotics. And his main focus is to work and to provide for his son. He is, like I said, he is the widower, and he wants to make sure his son has what he needs or the best he can have. I would like the court to know behind me, as in most hearings, my client's father has always been here. I know him. Actually, I knew him before I knew Noah. That's how I got the introduction, and he's had support here the entire time. I just want the court to know, I think that his character at the time was abysmal. It was bad. It was just, I mean, again, wait 3 months, or it was 3 or 4 months if you want to have this relationship. Just bad judgment. And I don't have a time machine. I can't put him in it and have him rethink what he did. And now he's sitting here for that. But the need to protect the public, Your Honor, I don't think there's going to be a need to protect the public. He's going to be on the same bond conditions. He's going to follow those conditions, and anything that's required through the deferred agreement and through probation, he will do, and he will not balk at anything. Again, he has no record. So I join in with the argument of the state on a lot of the points, well, on all the points. Like I said, I can't come here and say, well, it happened, but it happened and there's no way around it. It was wrong. He shouldn't have done it. And I just want the court to consider all the other things about him and the good things that he's done in his life up to this point. Thank you very much, Your Honor.
Thank you. Mr. Gosman, I'm going to turn to you now, and this is your opportunity to tell me anything you want me to know about this matter, about you, if you want to clear up any information that you believe was not stated correctly by either of the attorneys. So this is your time to tell me anything you want me to know before I sentence. You don't have to give a statement. It's just your opportunity.
Okay. I would like to remain brief. However, I do think that,
And I'm just going to ask you to speak slowly if you.
okay, will do. I believe my attorney spoke well for me, and I share those points. I do want to apologize. I want to apologize to anybody that this has affected. I want to apologize to the victim. I want to apologize to the family, and to the community. This is nothing I ever intended on doing. I didn't intend on doing anything wrong. I do agree that it was poor judgment at that time. I have definitely learned my lesson, as they say. That's what I'd like to say.
All right, thank you. Mr. Gosman, so you can understand, because this is your first criminal conviction, and I know you may have been in law enforcement before, but on the other side, and now you're sitting in the hot seat. So I'm going to go over what a judge has to look at, what I'm told I need to look at for sentencing. First, I have to look at how serious is this matter? Okay, then second, I have to look at the defendant, your character, your past criminal record, your employment, all of those things about you. And then I have to look at needing to protect the public. Not only is it needing to protect the public as a whole, but it's needing to protect the public, meaning the victim and the victim's family. So that's what the court looks at with sentencing. And so you can also understand that the court needs to look at probation first. I'm told from my higher courts, I must look at probation first, unless confinement is necessary to protect the public from further criminal activity from you, unless you need correctional treatment. You can't get the treatment outside in the public, or you've not engaged in it or sought it out, and you can only receive it then in an institution, or if probation would unduly depreciate the seriousness of the offense. Okay, so first I look at probation, unless it would unduly depreciate the seriousness of the offense. First and foremost, I want to update Mr. Davis. This psychosexual evaluation is in the electronic file. It was filed July 11th, 2025. I've reviewed it.
And it was, I asked that that's under seal that we,
I believe it is.
okay, oh, thank you.
But I have reviewed that document. I'm hopeful that Mr. Schmidt and he has as well. So everybody's reviewed that document.
Thank you.
And nothing jumped out at the evaluator. Nothing jumps out to the court from reviewing that. It sounds like you had a traumatic experience or time in your life with your ex-significant other who has passed away, and that really affected you. That didn't cause this to happen. It didn't cause you to seek out the 17-year-old girl, but it could be a factor. This is, at first blush, when you're looking at this case, without knowing exactly all of the facts as they've been stated on the record, and especially by the district attorney, it looks and it appears to be very serious. Mm-hmm. An adult who is 32 years old, who's engaging in sexual intercourse with a juvenile, even who has attained the age of 16, is serious. There are underlying facts here that the district attorney has been able to retrieve, as well as your defense attorney, in that this young lady consented, and she spoke to you about a relationship and having it develop and go from there. She was 16 or 17 when this all occurred. And the sexual intercourse didn't occur until she was 17 years and 11 months old. 1 month. 1 month. away from criminal convictions and criminal charges. However, that's on your side. When I hear the information as it relates to the victim coming through the stepfather, she was a young lady. She may have appeared to be more mature in the things that she said and how she poised herself and what she did. But she still had a teenage brain. She still had the maturity level of a high schooler because she was. And in looking at this situation, there's a significant power imbalance. You're 32 years old, started talking to her when she was 16, and then she was 17. You were an authority figure to her, somebody who could have potentially been a mentor, twice her age. You're twice her age. Now, 5-10 years down the road, twice your age may not be so bad. But here, NJ has not reached a maturity level to be able to thoroughly consent and to consider all of the things involving you, a 32-year-old man, an adult with a child. She has not had the life experiences to be able to do that, to grow. Because if you recall, when you were 17 years old, there is a huge maturity growth from 17, even turning 18 and being done with college, even after your first or of high school, and then even after your first year of college, there's a significant maturity level growth right there. And then an even bigger growth from your second year of college, third year of college, or even if she did not go to college, even just growing and being that age and experiencing life. She was not there. You knew that, and you knew that she had 1 month until she was 18. And that's the difficult part with this case, because I hear the impact that this has had on NJ. Granted, she was almost 18, but she was not yet in that position to be able to make a reasonable and rational decision to engage in a relationship with you. And now it appears to have significantly impacted her well-being, her future, her drive, and her life. You don't have a criminal history. You were at one time a police officer. You're no longer going to get to be able to do that job anymore. And you will no longer be able to work or volunteer around juveniles. And that means all juveniles, not just 16 or 17-year-old juveniles. That's significant, and that's a significant punishment right there. Usually the court looks at deterrence, a deterrence factor in a case, especially a case like this. But again, she was almost to that golden age of 18, where she could have made her own legal decisions, but she's not. So I don't believe that there should be a sentence, or there needs to be a sentence to deter you from continuing to do actions like this, or to deter the community as a whole from committing crimes like this. When I look over the deferred judgment of conviction, it seems reasonable. You're pleading guilty to a felony. If you don't follow the law to the letter, that means that this agreement can be revoked. That means one probation violation, one misstep, one mishap, one something, and this will be revoked. And then you will be in front of the court for sentencing for that felony. And at that time, you will no longer be able to use or possess a firearm for life or vote in any election until your rights are restored. So you can have no contact with anyone under the age of 18. This will run for 60 months or 5 years, and you must pay a $150 fee to the district attorney's office. You must do that within 60 days. I'm going to tell you that's the #1 reason I see these being revoked. People don't pay that $150. Okay, so it's very important that you do that. I do find that the deferred judgment of conviction as it relates to the felony count is appropriate. That's a huge hammer over your head. And it'll fall, and only you have the ability to determine if it will. When we're looking at the misdemeanor convictions, in this case, probation would be necessary to ensure that you abide by the law, you follow the law. Somebody's monitoring to make sure that the deferred judgment of conviction is being followed. What is the length of probation that's being asked for?
2 years.
That's what I thought. I just wanted to make sure. All right, so 2 years of probation so that an agent can ensure that you're following the letter of the law. You're doing what you need to do. So 2 years probation for both of those counts. I was contemplating whether or not there should be initial jail time. There should be conditional jail for these convictions. But hearing the facts coming from the district attorney's office that the former district attorney overcharged, there should have only been 3 charges. And these are the 3 charges that should have been initially charged in the criminal complaint. And the other facts about the victim, her age, her consent, her discussion with the officers in the interview. I'm not seeing that conditional jail would necessarily be appropriate. You did a stupid thing that has the potential to follow you for the rest of your life, that will follow you for the rest of your life, and a stupid thing that has now decided that you will no longer be able to serve as an officer. The law can't fix stupid. And any conviction that I give you right now, if I give you jail time, all it's going to do is be a punishment for doing that. So what I'm going to do with regards to these 2 convictions and charges, I'm not going to do a withheld sentence. I'm sure your attorney went over with you what that is, a withheld versus an imposed and stayed. I'm going to let you know exactly what you're going to be facing if you violate. So it's very important you follow the letter of the law. With regards to count 5, the court is going to sentence you to 6 months in jail. And as to count 10, 6 months in jail, consecutive to each other. So you have to serve one, then the other, imposed and stayed. That's going to be hanging over your head. So you know that punishment, and the punishment will be hard and strong. That would be a total of 1 year in jail. On probation, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. No contact with any minor under the age of 18. No work with any ability to have contact with a juvenile, and that includes volunteering. Random testing of blood, breath, or urine or hair follicle to determine if you're using any substances or alcohol. Gainful employment. No bars, taverns, liquor stores, or casinos, or any establishment that has the primary purpose for the sale or the service of alcohol. No contact with the victim or victim's family. Mr. Schmidt, am I missing a condition?
No, those are the ones I would have wanted.
All right, any condition that you would see, Mr. Davis?
I don't know if you can do anything on this, but he's raising a 6-year-old boy, and he can have contact with this child, and then Your Honor, for like I don't know, know if they still do it, like concerts or school. Is he able to go and watch his child function with other like sports or stuff like that? They have like a thing for that. I guess I didn't really, I didn't even think of that until you brought it up.
All right, and so he may have contact with his children and any family children, if you're going to do a Christmas, those things, because I'm sure your family's there, all of those things. So it doesn't prohibit you from having contact with your family, okay? I'll say, so you can have contact with any family member, even if it's a juvenile. And with regards to the school events, you can attend your children's school events, but again, no unsupervised contact with a minor. So you can go to the basketball games, you can go to the concerts, but you can't have any unsupervised contact with anyone under the age of 18.
Maybe part of that, he notify the probation agent if there's a function he's going to, then everyone knows what's going on.
Yes, I like that. Notify your probation agent. And also you're going to have to notify the school. I think this is one of those charges. You have to notify the school of this charge. And it depends on which school it is. You would need to notify them that you would be attending those types of things. Because I did have a similar incident with an individual who got charged with failing to notify the school. Okay, so it's very important that you do those things.
I have nothing further than, Your Honor.
Thank you. $443 in fines and fees for both of the misdemeanors. And you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. You're going to need to go to the sheriff's department and provide that. I do not believe that this is one of the convictions that it can be expunged with, but that's up to the Department of Justice. So if you wish to ask to have your DNA expunged from the CODIS system, you would need to write a letter to the Department of Justice, not this court, not to me, to the Department of Justice. You can Google it. It's pretty easy to do. I think that covers everything, Mr. Smith.
Nothing further from me.
Mr. Davis.
He had no jail credit, so it covers everything.
All right, thank you.